docket. Case number 111401, State of Kansas v. Neese.
May it please the court, Michael S. Holmes, second for petitioner and appellee. If I could please reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. I have to respectfully disagree with both of the two parties who just spoke beforehand and with a lot of the question that's going on in the court. In my opinion, this really is not this complicated. If we look back at the purpose of the Kansas implied consent law and other implied consent laws, it gives us focus as to why this is really not this complicated of an issue. This is an obsolete law. Its fundamental purpose no longer exists after Missouri versus McNeely. In 1966, this is when all these wheels were put in motion with Schmerber versus California. And the United States Supreme Court, which was, I think, understandably interpreted as saying that if you had a DUI arrest, that exigent circumstances automatically existed due to the dissipation of alcohol from that individual system. And especially at that point in time, if it's an arrest at 2 or 3 o'clock in the morning, there weren't iPads, there weren't cell phones, there weren't fax machines at judges' offices. And so all the courts interpreted that as saying, if you have a DUI arrest that's valid, so you have a lawful arrest, then you then have exigent circumstances to do a warrantless blood draw if the officers want to do that. That understandably sent legislatures across the country into panic mode and very concerned about officers forcibly taking an individual's blood at 3 o'clock in the morning if they're refusing. That was the purpose of the implied consent law. The implied consent law is one of the world's greatest misnomers ever. It was never intended to imply consent to anything. What it was intended to do was allow officers the lawful ability to lawfully coerce an individual into acquiescing to what was already a constitutional search. It was constitutional because you had a lawful arrest and you had exigent circumstances. That is it. That was the only intent and the only purpose of the Kansas implied consent law. We are so far afield from the original intent and the very foundation of the implied consent law. That is what is creating the problems now. It is not the law itself. The law itself is very clear and very concise and very easy to interpret. The United States Supreme Court completely removed the foundation for the implied consent law when in Missouri versus McNeely they said, hey, wait a second, yes, we said that exigent circumstances existed back then, but that was in 1966. Both the law and technology has changed since then. We know that blood alcohol doesn't dissipate that fast. We know that officers can get search warrants at any time of the day and do so all the time. Over 40 years have passed since that point, since we first came down to the decision. And so no, you don't have exigent circumstances every time you arrest somebody. It's not really that complicated then. You go back to an arrest, and if you want to have somebody submit to a search, if it's warrantless, it's presumed to be unconstitutional. Law enforcement now has to find a different exception to the warrant requirement. Again, this is still not complicated. What is complicated is the antiquated law of the Kansas implied consent law still exists. And so an officer has to tell an individual if they don't consent, they're going to lose their license for a longer period of time. And the refusal statute that was just discussed beforehand, if they don't consent, they're going to be charged with the crime of refusal. And this court, time after time over the last 40 years, has interpreted the Kansas implied consent law as being coercive. And it was fine. It was lawful for it to be coercive during the last 40 years. Because the fundamental foundation for the implied consent law still existed. If you had a lawful arrest, there were exigent circumstances because that is how everybody interpreted Schmerber versus California. That foundation that made the law that has existed for the last 40 years perfectly fine and perfectly lawfully coercive no longer exists. Now DUIs are to be treated, which they probably always should have been, but are to be treated just like any other criminal offense. And all this verbiage of trying to keep drunk drivers off the road and having a public safety interest in DUI law, all those things, those are perfectly fine in the licensing aspect. If this was an argument, as it was in Martin versus Kansas Department of Revenue, as to if there's a constitutional violation, can they still take their driver's license? Sure, but that's not what we're talking about right now. We're talking about the Fourth Amendment. And when you start to overlap licensing with criminal offenses and constitutional rights, that's really where the problem now exists. You have the Kansas Implied Consent Law, which probably lawfully still can be applied to licensing issues, but now is going to make it awful darn hard for a law enforcement officer to obtain lawful consent, intelligently and knowingly given, free of duress or coercion, because this court has consistently interpreted for the last 40 years that the Kansas Implied Consent Law coerces people into consenting to a breath or blood test. You just can't do it anymore.
So what happens to our implied consent law? What are you arguing here?
Well, the legislature never asked defense attorneys what should really happen, even though...
Well, I'm asking you.
They need to get rid of the implied consent law.
I mean, it's still good law, though, isn't it? I mean,
it's terrible law, but yes, it is still valid law.
Valid law as well.
Yes. It's now a law without a purpose. If the purpose was to prevent officers from physically forcing somebody to take a breath or a blood test, that no longer exists anymore, and the legislature lost sight of that purpose a long time ago anyway. And now the problem is the legislature has so, well, I don't want to use that word, but so manipulated what wasn't intended into now refusal statutes and in criminalizing consent and all these other things, which never had any place there. And it's so overlapped and intermeshed with licensing issues, which don't have really any import on the Fourth Amendment issue and on being able to convict somebody of an actual criminal offense of DUI, that you have this mess where, yes, it is still valid law, but officers now make it almost impossible for them to obtain voluntary consent free of coercion, because they're going to, by definition, coerce the person or try to coerce a person into submitting to the breath or blood test, which renders any consent under the Fourth Amendment invalid. And that's the problem, and that's really how simple it really is.
So what are we left with then if they repeal the statute? Under your version, there's an arrest for DUI, and then the officer says, would you consent? And the person is free to say, no, I'm not going to do that. And then the officer says, well, maybe I'll get a warrant. And you proceed with the warrant or try to find some other exception.
Sounds pretty simple to me.
Well,
yeah.
Is that your position?
It's exactly my position. And it's what should have been done.
Excuse me. Doesn't this all go wrong because they say there's no right to refuse now because of part of what they're informed?
It all goes wrong because the legislature forgot why the law is valid. The law is valid because it never forced somebody or coerced somebody into consenting to an unconstitutional search. It forced them or coerced them into physically acquiescing to a search that would have been valid under the Constitution with the lawful arrest in exigent circumstances. That no longer exists. And Justice Nuss, to get back to your question, I know it sounds almost trite because it's so simple, but DUIs don't deserve any special treatment other than murder cases or rape cases or methamphetamine cases. Why does the Fourth Amendment bend to be different in these situations? It shouldn't be. It was never intended that way. The Constitution doesn't have any special provisions for DUIs written into it, nor would they have any special provisions for murder cases written into it. You have a lawful arrest of somebody who you believe is driving under the influence. You don't tell them they don't have a right to refuse. You don't tell them if they don't consent, you're going to criminalize it. You don't tell them all these other things that have no place in the criminal justice arena. You ask them, hey, would you like to take a breath test or a blood test? And they can probably even say lawfully, as this court has interpreted, if you don't consent to that, I think I have enough probable cause to go get a warrant, I'm going to go get one. All of that's lawful and it's really simple, and that's all they need to do. And if they did that, there wouldn't be a whole bunch of defense attorneys like me standing up every time somebody gets coerced into submitting to a breath test or blood test. And then you could have the exception to the warrant requirement of voluntary consent. The problem is you can't have that right now because you tell the people if they don't consent, it's a crime. You tell them if they don't consent, they're going to lose their license longer.
But those are accurate statements, correct?
Accurate statements, but that was a choice of the legislature. Those are accurate and they're fine if all you're trying to do is take their driver's license from them. It is not accurate and fine if you're trying to establish voluntary consent free of duress or coercion.
Because you're saying it's coercive. But did you make that argument in your brief?
Yes. Yes. We argued very specifically that it's basically impossible for coercion to be given because the very definition and nature of the implied consent law is to be coercive, as it was allowed to be for a very long period of time because it was already a lawful search. It's not a lawful search anymore, so you can't be
I
coercive.
think you might have misspoke. You mean it's impossible for consent to be given?
It's impossible for consent to be given free of coercion.
Okay.
Because the implied consent law itself is by nature and by definition coercive. So it really would be an easy fix. It just is not politically expedient. You get rid of the implied consent law if you want to convict people in the criminal arena, and you ask them to submit to a breath or blood test, and if they don't, you get a search warrant. DUIs aren't special. They shouldn't be treated specially. If you want the licensing issue and the legislature is more concerned with taking somebody's driver's license, then fine. Tell them that you're going to take their license for 10 years if they don't consent. Tell them that it is that you're going to criminalize their refusal or take their license longer otherwise. But that then will render your search for the breath test or the blood test unconstitutional because you're then coercing them into giving that to you without a warrant, which is presumptively unreasonable, and without any other exception to the warrant requirement.
Does that depend on us finding that it's unconstitutional that the criminal statute is unconstitutional? Why is it coercive if it accurately tells them what the law requires and that's a valid law? Isn't that just informative?
Well, let me explain it to you this way, and I'm not trying to avoid the question. The legislature was within their power to pass whatever laws they choose to deem fit. Just because they pass a law doesn't mean that law doesn't violate the Constitution, or doesn't mean that law can't render somebody's consent coerced. If they would pass a law saying methamphetamine is a scourge on society, if an officer has reasonable suspicion to believe that an individual is manufacturing methamphetamine in their house, they should be allowed to search that house without a search warrant. And if they don't consent, they're subject to 90 days in jail minimum upon the time of arrest. That would be a valid law. The officer would be within the rights of the law to tell that individual when trying to search their house, if you don't consent or let me in, you have to go to jail for 90 days. It would be a correct recitation, but nobody in this courtroom today would think that would not violate that individual's Fourth Amendment right to be free from unreasonable searches and seizures.
Okay, so I think your answer to my question is that your position requires us to find the criminalization of consent statute unconstitutional.
The criminalization of consent statute, I think, is unconstitutional, but it's not imperative for you to find that for this argument to stand. The only thing that, in fact, you don't even have to find that the Kansas implied consent law is unconstitutional. It probably is not unconstitutional on its face. What you do have to find is a very simple Fourth Amendment analysis based upon Missouri versus McNeely. It is a warrantless search presumed to be unreasonable. There is no longer the exception to the warrant requirement of exigent circumstances unless the state's going to try to prove that out, which is going to be hard. That only leaves consent free of duress or coercion. You cannot give consent free of duress or coercion under the current state of the law because it is coercive by nature.
And again, that's where I'm losing you, because I'm trying to figure out why, if it was a valid law and it's not unconstitutional, if it is valid and constitutional, and you advise somebody accurately of what that law states, why is that coercive?
Because it is coercive. Because if I tell you if you don't give your consent, you're committing a crime, that's by definition coercive. Under the Kansas implied consent law, if I tell you if you don't consent, I'm going to take your driver's license from you for a year, that is by definition coercive. That is fine for the licensing arena because this court has determined in Martin versus Kansas Department of Revenue that your constitutional rights don't necessarily apply to your driver's license. But if the state, which is their burden, to prove that they have a valid warrantless search, they have to prove an exception to the warrant requirement. They can't prove exigent circumstances anymore based upon Missouri versus McNeely. That means they have to prove consent, free of duress or coercion.
No, wait, let's roll back there. They can prove exigent circumstances. It's just they have to do it on a case-by-case basis.
And it's their burden.
They do not have a per se rule.
Right, it's their burden. They didn't try it here. It's going to be really hard to prove with iPads and cell phones and everything else.
That may be true, but there is a niche of cases where it's possible. It's hypothetically possible.
Absolutely.
Right.
It is hypothetically impossible to prove consent free of duress or coercion under the current state of the law. Doesn't mean the law is unconstitutional. It means the searches based on that law are unconstitutional.
And no other exception applies. That's
Yeah,
your
I mean, if you can come up with another one, fine, that's a
Well,
state's
the state
burden.
was arguing search incident to arrest in the last case.
But with
You
the
wanna
search,
address that?
yeah, search incident to arrest, Missouri versus McNeely made very clear doesn't apply in Fourth Amendment for DUIs, and so that's why I didn't go into it.
Okay.
If there are no other questions?
I have one question. Why isn't the state, if we grant for purposes of argument that this is coercive, why isn't what is being coerced the individual's cooperation to submit to a test to which they've already consented?
They haven't already consented. The consent has to be intelligently and voluntarily given, free of duress or coercion.
And respond to the state's argument, generally speaking, that when an individual agrees to be licensed to drive, they are deemed to have consented, and they've been given all the information. They're going to be, whether they have actual knowledge or we're going to give them constructive knowledge of what the law is, that's consent.
That is one of the greatest misnomers of the Kansas implied consent law. It was never intended to imply consent to anything, ever, other than searches that were already constitutionally permitted. That's why the implied consent law at its foundation required reasonable grounds, which meant a lawful arrest, and then they already had exigent circumstances versus based upon Schmerber, and so it was a constitutional search. They
I understand
weren't
that's
implying consent to something unconstitutional. If they did actually imply consent, they'd have to, I don't know. There would be no way to imply consent to something like that. You can't imply consent to a search of this nature. Licensing issue, fine. Again, that's separate. But then we really should divide licensing law from criminal law. Here, they're still intertwined, and I'm only arguing right now that the criminal search is illegal.
How do you respond to distinguish the case law in other arenas where the court has said you can have implied consent? You can have a bargain for consent where a certain benefit is conferred and the individual gives up rights in order to receive that benefit.
That's true, but that hasn't ever been applied to driver's license or driving issues other than in the licensing side. And I'm okay with it on the licensing side. You give up something in order to get your driver's license. If you want to refuse to submit to a breath test or blood test, that means you lose your driver's license, that makes perfect sense. And that's what the line primarily of all the United States Supreme Court cases dealing with that have dealt with. Licensing or regulatory type things.
Your argument is just that consent in the Fourth Amendment realm is something higher and greater
Entirely.
and can't be reached by these kinds of statutes.
Absolutely, it was never intended to be.
I'm not sure how intelligent my question's going to be. Let's see if you can untangle it. In your case, your client gave consent after receiving the notice. And in response, or one of the questions that came from Justice Lukert was whether the notice that was given was accurate or not. My question goes to based on McNeely, there's still a sliver of potential cases where there could be an exigent circumstance, so the search would be lawful. So it's accurate to tell the motorist that you could be prosecuted for refusing because there's this complicated. But my problem is the calculus that it takes to figure out whether it would be lawful or unlawful to prosecute seems to me to be so difficult that it still renders the consent not voluntary and informed. And I know you would agree with, I realize I'm saying something you would agree with, but I'm trying to figure out if you can expand on that a little bit because I kind of want to ask the other guys the same question. You see what I'm getting at?
I completely understand what you're getting at, and this is probably a simpler answer than what I should give. All of the reason we're arguing here today is because the legislature lost sight of what the purpose of the implied consent law was. And they keep going down that slippery slope into criminalizing refusals, into saying it's an implied consent to all searches, and into completely losing sight of what happened. And that's why what you're going through in your mind right now, imagine you being a lay motorist or a lay person driving and trying to figure out what you can do and what you can't do after being read all these things and told that if you don't consent, it's a crime, and everything else. It just makes no sense when really the law itself fundamentally is simple. If it's a warrantless search, it's presumed unreasonable absent an exception. Those exceptions would be much easier for the state to prove if they didn't threaten the licensee or the defendant with all these potential consequences before trying to get consent. And so I don't think we even should get to the point where we're determining that whether they can be prosecuted for refusal or not refusing. If you eliminate the statutory coercion and you eliminate criminalizing an individual's right to either consent or not consent, then we can go back to arguing as to whether or not there were exigent circumstances and whether or not there was a voluntary consent, which is really what the law was intended to do and what district courts should be intended to ferret out.
So, I mean, I guess what I'm getting at is it doesn't seem right that the accuracy of the notice is the only test as to whether the consent's free and voluntary.
And that's my point. Is it doesn't. If the notice accurately recites the law, it still doesn't mean it's not coercive. And in fact, this court has found for the last 40 years that the Kansas implied consent law is coercive. Well, if it is coercive and it's intended to be coercive, how can you give consent free of coercion?
You may address this on your rebuttal, but what are you asking us to do about your client in particular?
My client in particular is easy. The legislature's issue is not. My client, the search should just be declared to be unconstitutional because it's warrantless and there wasn't voluntary consent free of duress or coercion, which will be the same story over and over and over again until the legislature fixes the law. But it doesn't render the law itself unconstitutional, which is what we were talking about earlier. The legislature can threaten and coerce people if they want to, but it makes it awful hard then to prove voluntary consent for a prosecutor.
Very well. Any further questions?
Just real quickly, you started off that the implication of the implied consent is based on, or the history is based on, it's post Schmerber, and it's based on that it was a constitutional search, it allowed for a constitutional. Do you have any legislative history that was the assumption that underlies?
I think I quoted quite a bit in my brief from
Okay.
Adi, and it does a pretty good job of going back through the fundamental principles behind it, because I was one of those defense attorneys for years who kept on arguing that, you know, the Kansas implied consent law was unconstitutional and that they couldn't do it. And they would always come back, understandably, and say, no, it is coercive and they are being threatened, but they're only being threatened into doing something the officer could do warrantlessly anyway.
Okay.
And so it goes through that.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, Brock Abbey, Assistant Sling County Attorney on behalf of the state. I'll begin, I guess, with I disagree with my colleagues' stated purpose for the implied consent law. I believe the implied consent law contains within it its own section stating its purpose and that it's to be liberally construed to protect the general health, safety, and welfare of the state. And I believe that this court has consistently affirmed that, and that the purpose of that law is to reduce the incidences of drinking and driving, alcohol-related accidents, injuries, and fatalities. And I believe that's the purpose of that. It advises anyone who comes into contact with law enforcement first that if they've been arrested for DUI, that the statute implies this, and I think it does imply it. If it's not implied, it'd have to be explicit, and the statute in and of itself says anyone arrested for a DUI offense in the state is deemed to have consented to this test. And to me, that's implied consent because it's written in.
Why can't the officer just proceed to administer the test then?
Well, for two reasons. This court has required, first of all, that, at least in the administrative side, that it's required for an officer to provide the implied consent advisory. Second, I think if I understand your question right.
And in conjunction, the officer obtains consent. Verbal consent, because silence is a refusal.
Correct.
So if there's a refusal, typically you don't proceed then.
To getting the test?
Yeah.
Right.
So the implied consent sounds good, but in practice, it hadn't been any kind of consent at all, because you have to do the procedure in the field and either get a consent or a refusal at that time.
Are you asking about doing the procedure of like field sobriety testing? Is that what you?
I understood you to argue that implied consent is that the party's over because you've consented to it, and so there was consent, so there's a exception to the Fourth Amendment. But in practice, that implied consent is not treated like a consent at the time of the arrest.
Yes, Your Honor. I think it should be treated at the time of the arrest, whether there was consent given or not. And I think the State versus Juan opinion that I put in a Rule 609 letter addressed that. And the State versus Slayton out of New Mexico said that whether it's implied consent is coerced or not should be determined at the time of the stop. For purposes of the implied consent, for it to have any meaning or any valid purpose, that's when we should consider it. Anyone who's arrested for DUI and goes through all the testing is later transported to sheriff's office or jail, wherever it is, for further testing, and provided this implied consent and advised of all the warnings, which again they have to do, is going to see that, I think, in a less beneficial way for them to give the yes answer or consent to testing than if we go back to where the privilege has been granted and where the voluntariness should be determined. The act of driving on the roads is where the consent is given, not subsequent.
So if I could summarize it, it sounds like your position is that legal consent has been given when the driver chooses to drive.
Yes.
Is that right? And then what happens after a stop is a coercion of cooperation.
Right. And what happens after the stop, their answer, it's going to depend on what the impact of...
In other words, what happens with those advisories has nothing to do with legal consent. What it has to do with is compelling cooperation.
Compelling cooperation. And again, whether it's coercive or not, I think Justice Spires' questions earlier were, what are we compelling? Is it compelling a refusal or compelling a submission? And I think the state's interest in that is compelling the submission. The state doesn't really have any interest in compelling a refusal. We don't get the test results for either the administrative or criminal side if there's a refusal. So I don't think the state benefits from that.
You win either way, don't you?
I disagree. I guess in the criminal realm, if you understand, if we benefit whether there's a refusal or not as far as criminal prosecution. Is that the question?
Well, if you can compel the submission, it may lead to proof of the basis for the arrest, leading to a conviction for DUI.
Correct.
If you somehow compel a refusal, then you prosecute that person for the refusal.
Now we do. But as far as the DUI in of itself, there's a separate section that we'd have to prosecute the DUI under without the per se violation, the incapable of safely driving, as was mentioned. And in my experience in prosecuting these cases, those are quite a bit more difficult to prosecute than giving a jury a .08 number. They understand that, rather than the objective, a jury looking at all of this evidence you're presenting, whether it's field sobriety testing or visuals of balance difficulty, stuff like that, whether you're going to convince 6 or 12 people, whichever it may be, that that person's incapable of safely driving. It's a lot different whether you're going to convince those number of people that they were .08 or more based on either a blood or breath test.
Do you agree that there's a constitutional right to withdraw that consent, even if it's...
No, I think, and I cited in the brief, Broussard Salaloja, I think, stated that. I know it's
which
a
is
Court of
based
Appeals.
on Schmerber and Neville, which are questionable. Post-McNeely, do you think, post-McNeely and Camera, perhaps more importantly, do you think there is a constitutional right?
No, and I disagree with the impact McNeely had. Justice Sotomayor, I think, was explicit that what they were addressing is only the exigent circumstances exception, not any of the other exceptions. And as Ms. Isherwood noted earlier, they endorsed the implied consent statutes and noted that there are significant consequences when you withdraw that consent. And that was 2013, and obviously the implied consent laws have been around for a lot longer than that. And as noted in our brief, there have been the refusal criminal penalty laws in other states even longer than 2013. So I believe the Supreme Court at that time would have known of those laws when they suggested that there are significant penalties or consequences for withdrawing that consent when they endorsed them, and that was a plurality opinion at that point.
So if there's not a constitutional, does the implied consent statute basically set up a statutory mechanism for the withdrawal of the consent?
Right, and I think I cited a Nebraska case in my brief that said refusal is not a right, it's controlled, or a constitutional right, it's a statutory right, and whether the statute grants that is up to the state. In this case, I think the state has granted a statutory right. You obviously have the choice to submit to the test or not, but through the implied consent law and now the test refusal law, they've, through statute, enacted separate penalties, I guess based on whether you decide to cooperate or not.
Can the state compel compliance with that? If there's a statutory right, can they coerce, compliance with the, so in other words, give me information that coerces me to believe that I've got to go along and that I can't and shouldn't exercise my statutory right to revoke my consent?
I think they can, and I think that's what this court said in Martin was the purpose of that law is to be coercive, to coerce the submission to a test.
And can they do it, though, outside the administrative context and in a criminal capacity? Or it
I think
infringes
so.
on my individual liberty?
I think so, because there are the exceptions to the warrant requirement. Consent, obviously, and as my colleagues other colleagues have noted, there's the possibility that the exigent circumstance could still come into play on certain occasions after McNeely, a search incident to arrest. It's the Bernard decision out of the Minnesota Supreme Court just this year, I think, cited a 9th and 11th Circuit cases that have applied the search incident to arrest as a categorical approach, not one that's probable cause plus, or case by case, it's categorical, and have allowed that search to take place under that exception. So I think if there's an exception where law enforcement's entitled to get that evidence, then they can compel it.
But are the 9th and 11th Circuits pre-McNeely case decisions? I believe at least the 9th Circuit one is.
I don't know if I wrote the dates down. I just noted that that Bernard opinion collected cases. There were a couple state cases too. Pennsylvania, I think, was one of them that applied the search incident to arrest for implied consent, or the search that you would get through implied consent in this case.
What is the impact of Mr. Holland's initial point that the implied consent, kind of as its foundation, was that the search that you were consenting to was deemed constitutional by Schmerber, and McNeely certainly calls that into question. Does that have an impact on the whole foundation of implied consent? And if it does it impact the situation we have here?
I don't think it impacts it. McNeely, I think, stated that Schmerber is still good law. It just redefined that there's no per se exigent circumstance. I think so with implied consent, McNeely didn't really change that. Does that answer your question?
Yeah, I guess your point is it doesn't change anything, it doesn't impact implied consent. Or Mr. Holland's point was that's the very foundation of implied consent, is you're deeming to consent to something that was constitutional, now it's not.
Well, I don't agree that it's not constitutional. I think if you're going to base the implied consent law only on the exigent circumstances, then McNeely, I guess, did change it, saying there's no per se exigent circumstance. But that's only one exception.
I understand. Right. Okay.
As far as outside the realm of the warrant exceptions, I think the U.S. Supreme Court has indicated that the touchstone of the Fourth Amendment is reasonableness. And so Skinner noted that in allowing the searches of railroad employees based on the danger to public harm. And as far back, I think I cited in this brief, since the 1970s in the Pop case, this court has recognized the devastating impact drunk drivers have on the roads and the innocent motorists and bystanders on the roadway. And so as far as the reasonableness test, you would balance the government's interest against the individual's interest. And as noted in that pop case, the government has a compelling state interest in protecting those roadways. And I would argue that you'd balance that against, in this case, Mr. Neese's interest in concealing evidence, obviously a breath test in this case that he eventually did submit to, against what Maryland versus King said, when you're taken into custody, lawful custody, you already have a reduced expectation of privacy. And in this case, you have the implied consent, notice, and advisory that you are presumed to know the law, the statute. And so you're presumed to know or be on notice that once you're arrested for a DUI offense, there's going to be some expectation that you may be tested, or a reduced liberty interest, or reduced expectation of privacy once you're taken to a jail. Obviously, you're searched extensively. And again, the search incident to arrest cases have said that that can be a full search for any weapons or evidence of any crime which may be concealed about the person or may be destroyed. Obviously, we're concerned with that, as well as the safety of officers and the jail personnel and staff. And again, I would like to, I guess, just address the Court of Appeals opinion that's here for the petition for review, and especially Chief Judge Malone's concurrence, where he noted that, in this case, Mr. Neese was properly advised, based on the stipulated facts, in this case, that he was properly advised of the legal consequences required by statute and through the DC-70, and that being advised of those legal consequences does not render the consent involuntary, and it's still a reasonable search at that point, a reasonable request. And I think supporting the reasonableness of the search in the implied consent context is, before an officer even gets to that point, they have to have probable cause to place you under arrest for an offense, a DUI, and then, which translates obviously into what the statute requires as reasonable grounds. So these aren't just general motorists on the road that are stopped for any infraction. They're ones that have gone through testing and this probable cause and reasonable grounds have been developed, which balances against the consent and whether it's coercive. We want them to take a test, but, and I guess this brings McNeely back into it, they buttressed their no per se exigent circumstances with the implied consent law, which they cited, and cited Kansas in particular, that would require probable cause before just requesting a test.
While we're on the Court of Appeals decision, I've been scratching my head about Judge Malone's application of the good faith exception, and I'm not sure I quite understand. It seems like if it's coercive, and regardless of whether you're following the statute. But that aside, the preliminary question is, you didn't ask us to apply the good faith exception, did you?
I didn't.
Okay, so it's really not in play.
Okay. And I notice my time's up unless there's any further questions. The state is obviously asking this court to affirm the Court of Appeals, which reversed the district court.
Any more questions? Thank you, counsel.
Thank you.
I hope that we can agree that licensing issues are separate and apart from the constitutional implications associated with the Fourth Amendment. If everybody agrees on that, the analysis quits being quite so murky and quits being so confusing. If we just do a simple Fourth Amendment analysis, the way that we were all taught in law school and the way the law has always been, you start off with an arrest. Fine, the arrest is valid. Let's say the officer has probable cause for arrest. That gets you the arrest, that gets the individual to the police station. Next, if you want to execute a search without a warrant, we're going to start off with the presumption that is presumed to be unreasonable. That gets us here and now. The officer, or the state in this case, then at the time of trial has to prove that whatever search was done after that falls into an exception to the warrant requirement. Again, simple analysis. That was always easy for DUI law for a long time because Schmerber said search with exigent circumstances always exist on a DUI case. That doesn't exist anymore. That doesn't preclude the state from proving another exception to the warrant requirement, but the state has to prove it, not the defendant. What exception are they going to prove? Well, they could try to prove exigent circumstances, but they didn't do it here because everybody knows it's going to be really hard to do now. They can try to prove consent. Well, that's fine, but as part of the analysis of knowing, intelligent, and voluntary consent free of duress or coercion, the state is really stuck in a corner because now they are, by definition, statutorily coercing people and threatening them, not only with taking their driver's license from them, but telling them if they don't consent, it is a criminal offense. They are criminalizing their consent. Under any simple black law analysis.
Well, counsel, they're not criminalizing their consent if you view the consent as being given at the time they choose to get their driver's license.
Sure they are. KS 8-1025 outright criminalizes lack of giving consent. That is criminalizing not giving consent. That is by definition a criminal sanction and penalty. So yes, the legislature has criminalized not consenting. And yes, by definition, it is coercive. And no, nowhere in the Kansas implied consent law does somebody actually imply their consent to drive a vehicle. And on top of all that...
Counsel, let me just stop you there for a second, because you've made what may even be an elegant and compelling argument based on legislative history and purpose. But I guess where I'm stumbling is over the actual language of the statute, which very clearly, to me at least, says a person who drives a vehicle, I'm paraphrasing, is deemed to have given consent, subject to the provisions of this act, to submit to a test. So how do you, when we, even if we find your legislative purpose argument compelling, how do we get around that plain language of the statute, which seems to say that what the legislature meant is, yes, you are giving consent when you agree to drive?
We can all agree that the Constitution trumps statutes, correct? And individual constitutional rights come before statutes, the legislature statutes.
Right, but earlier I understood you at least to say that your argument does not require a finding that this statute is unconstitutional.
It doesn't, and I don't care what it says in the statute, to be honest with you. For my interpretation, the legislature can deem consent to a search of my house. Doesn't mean it doesn't violate my Fourth Amendment rights. The legislature can say whatever they want to in the implied consent law. Most of the people who are voting, no offense to the legislature, don't remember what the initial purpose was or understand the workings of the law to begin with. The legislature can say they deem consent to a breath or blood search, a blood test, as soon as you drive a vehicle, but that doesn't mean it doesn't violate that individual's Fourth Amendment or constitutional rights. That's why I said the legislature can pass whatever laws they want to, but if those laws directly impact my Fourth Amendment rights, it means that my Fourth Amendment rights are still violated. The legislature cannot...
That's why we're confused, because I thought as well that you very clearly said during the opening portion of your argument that we don't need to find either statute, implied consent or the criminalization of refusal, to be unconstitutional, period.
Correct.
And I assumed you meant on their face or as applied.
What?
So I'm confused because it seems like your response to Justice Stiegel is
What? Okay.
that the implied consent statute as applied to my client here was unconstitutional.
No, because the implied consent law is not what is allowing the test results into evidence. The implied consent law is a process that this state has set up in order to obtain a breath or blood test. And if they're going to threaten somebody with criminalizing their refusal, or they're going to threaten somebody with taking their driver's license from them, and everybody, including this court, has always agreed that that was coercive. It used to be lawfully coercive, but now it's unlawfully coercive. It doesn't matter really what the statute says, and it doesn't really matter whether the statute itself is constitutional or not. The simple Fourth Amendment analysis is that's what the statute still says. And they tell the individual if they don't consent, this is what's going to happen. That renders my client's consent involuntary by a matter of law under the Fourth Amendment. And so it violates their Fourth Amendment rights. I personally believe the legislature needs to change the implied consent law because they make it very difficult for prosecutors or officers to obtain voluntary consent free of coercion now. But that doesn't necessarily mean the law is unconstitutional, and it still probably could be relied upon in order to take their driver's license from them if they don't consent or if they fail a test. But what it has done is it's rendered any test results to be inadmissible in a criminal context because they would not be gained free of duress or coercion, and there would be no other exception to the warrant requirement.
Well, that argument would... The state has another path. theoretically at least, and that would be if what is being coerced is not consent, but it's cooperation.
You still have to have consent. You still have to have voluntary exceptions to the Fourth Amendment. What voluntary exception would apply then?
And that's the implied consent statute.
You can't statutorily create an exception to the
So
Fourth
in other
Amendment.
words, your argument is the implied consent statute is unconstitutional.
If you're relying upon to say that that's creating a new exception to the warrant requirement that this court's never found before, then yes. If that's really where, maybe I was misunderstanding your rationale earlier. If you're saying that the implied consent law makes the test result per se admissible because they say that you impliedly consent, I didn't think the state was even going that far. But if that's what the argument is, then yes, that would certainly be unconstitutional because the state and the legislature can never, by statute, deem an unconstitutional search constitutional just because they passed a law.
Unconstitutional as applied to the search and to the prosecution, but not to the driver's license suspicion hearings. So
Exactly.
you're not saying it's unconstitutional on its face because traditionally it's not been applied to a liberty interest.
Exactly. Those statutes are perfectly constitutional for licensing issues. But when you tell them that, what they've done is then they've poisoned the water in the criminal context. Because the licensing issue, sure, coerce away, do whatever you want to. But if then you're going to rely upon that same search in the criminal context, you've poisoned the water and you can't get that in.
And so when is the implied consent advisory initiated and to be given as it applies to driver's license suspensions? How does it, the typical arrest happens, driving, reasonable suspicion, probable cause established, and then implied consent advisory is given. Where does that happen where it doesn't contaminate the criminal aspect of the case? You said it was simple. I don't think it's so simple.
In my aspect, you just eliminate it. The easy, clean fix is just get rid of the implied consent law. You would save millions of dollars. The state's broke anyway. Why do we have to have this double-headed monster that causes all this confusion and wastes more and more money? That's why I said the answer is simple. You just get rid of the implied consent law and you treat it DUI like any other criminal case. And you would end up with the same results.
But the state still has a procedure in which a defendant or an accused is advised of his implied consent as it pertains to the property interest of driving his vehicle or her vehicle.
Right.
How does that happen?
They wouldn't need to do it anymore. If you just let the person be convicted of a DUI or had their license suspended upon a diversion, you would save millions of dollars and you wouldn't have any of this mess. When you try to use administrative licensing coercion to obtain a criminal Fourth Amendment search, that's what the problem is. You're using something that was never intended to be used to coerce a test in the criminal aspect through the licensing aspect. And everybody knows, with a wink and a nod, that's been done forever. But now the United States Supreme Court made that foundation. They did that based upon exigent circumstances. It doesn't exist anymore. They closed the door. The whole house of cards comes down. If there are any other questions.
Any more questions?
I'm going to just make a statement of an apology. When I asked you that question about whether you made that argument, I was misreading a statement in page 13 of your petition for review where I thought you were arguing that the advisory was inaccurate. So I apologize for that.
Certainly. Thank you.
Thank you for your arguments this morning. The court will take this matter under advisement.